5 seconds to go. Start. A bench of two honorable judges of this court in Sessa Sterlite Limited Supra held the reading of Section 49 of the SEZ Act would reveal that the central government has got the authority to direct that any of the provisions of a central act and the rules and regulations made thereunder would not apply, or to declare that some of the provisions of the central acts shall apply with exceptions, modifications, and adaptation to the special economic zone. So, under the scheme of the Special Economic Zones Act, the central government has to first notify as to what extent the provision of the other acts are to be made applicable, or applicable with modification, or not applicable for the special economic zone area. It is in furtherance thereto the Government of India Ministry of Commerce and Industry, through its notification dated 21st March 2012 with regard to power generation in special economic zone, has declared that all the provisions of the Electricity Act 2003 and the Electricity Rules 2005 shall be applicable to the generation, transmission, and distribution of power, whether stand-alone or captive power. This notification would clarify that there is no inconsistency between the Special Economic Zones Act 2005 and the Electricity Act 2003. To recapitulate briefly, in the present case, no doubt, by virtue of the status of a developer in the SEZ area, the appellant is also treated as deemed distribution licensee. However, with this, it only gets exemption from specifically applying for license under Section 14 of the Act. The question in Sessa Sterlite Limited Supra was whether the appellant, a deemed distribution licensee, being a developer of Special Economic Zone SEZ and having a unit in the SEZ, is liable to pay cross subsidy surcharge CSS. It was held that the appellant would be liable to pay CSS for several reasons, including on the facts that it was using dedicated transmission lines belonging to the distribution licensee for the area in question. This court interpreted the expression open access and the rationale behind CSS and additional surcharge to observe that the former was payable by a distribution licensee and the latter was to meet the fixed cost of the distribution licensee of the area. The provision of open access, it is observed, balances the right of the consumers to purchase from a source of their choice. The rationale and the ratio of the decision, therefore, is that a deemed distribution licensee is treated at par and not different from a distribution licensee. Accordingly, if CSS is payable by a distribution licensee, the deemed distribution licensee is equally liable to pay the same. This decision, in other words, equates deemed distribution licensee with a distribution licensee for the purpose of supply of electricity to the consumers. Sessa Sterlite Limited Supra is not a decision for the proposition that deemed distribution licensee, to qualify as a deemed distribution licensee, must meet the criteria including the capital requirements as applicable by regulations to a distribution licensee. Further, the provisos to Section 14 of the Electricity Act distinguish between entities that are ipso facto deemed distribution licenses and those that are merely declared as deemed licenses without clarity on the necessity of making an application to obtain a license. For instance, the third and fourth provisos to Section 14 not only confer the status of deemed licenses to the state government and the Damodar Valley Corporation respectively, but also explicitly exempt them from the requirement to obtain a license. Entities not covered by these specific provisos would therefore be required to obtain a license. Stop.